hearing before the Board of School Directors concerning Mr. Apple and his proposed dismissal from employment from Juniata County School District. I'm Howard Kellen. I'm an attorney who's been engaged by the school board to serve as hearing officer and also as legal advisor to the board. Mr. Apple is represented in this proceeding by his attorney, Mr. Martin. Mr. Neff is here as the attorney representing the school district administration. Before we return to testimony, a couple of housekeeping matters. I have issued rulings to the attorneys on some objections that had been made, and I'll just summarize them so the audience knows what is happening. At the beginning of the hearing, during opening statements, Mr. Martin objected to some of the statements in the statement of charges. First, he objected to a statement in the statement of charges that Mr. Neff had violated the criminal statute concerning falsification of statements. And that was in the context of the administration charging Mr. Apple with having made false statements in connection with his civil suit against the school district. I'm going to rule in favor of Mr. Apple and sustain Mr. Martin's objection on that basis, on that matter, and have removed from the statement of charges just the allegation that in making the alleged misleading statements that Mr. Apple had committed a crime. He's not in charge of that crime. The school district is not authorized to prosecute for that crime. Although I don't think the school board is confused by that, to avoid any risk of confusion or prejudice to Mr. Apple, that will be removed from the statement of charges. Mr. Martin also objected to statements in what is paragraphs 11, 12, and 13 of the statement of charges, which identify certain felonies that Mr. Apple has been charged with. I'm going to overrule the objection, allow those statements of fact regarding the charge of felonies to remain in the statement of charges. In essence, those are predicates or conditions that are necessary for paragraph 14, which charges Mr. Apple with not having reported his arrest for those felonies within 72 hours to the school district as required by the school code. So for that purpose, I'm overruling the objection and allowing paragraphs 11, 12, and 13 to remain. That was one objection. The second objection that I addressed with the attorneys concerns some proposed testimony on behalf of Mr. Apple that Mr. Martin had wanted to ask questions about concerning alleged wrongdoing by another district employee that has nothing to do with Mr. Apple, nothing to do with the incidents that we're here about this evening. Mr. Martin's argument is that there's some relevance. I've ruled that I don't believe it is relevant. However, because in the event there were ever to be an appeal of this proceeding and some appellate body would disagree and find that that information is relevant, I've decided to allow him to present that evidence without personally identifiable information. So I've directed the attorneys that in that context there can be no mention of the other employee's name or job title or gender, and those three things are really not material in any event. So although I rule that I don't believe it's relevant and will so advise the school board, I am going to allow Mr. Martin to present that information subject to the conditions that I've stated. So with that, by way of housekeeping, when we stopped at the end of the last hearing, Dr. Etter was testifying. Mr. Neff had finished direct examination of Dr. Etter, and we stopped at that point. So at this point, Mr. Martin, on behalf of Mr. Apple, has the opportunity to cross-examine Dr. Etter, and we'll pick up there. Mr. Martin, you may proceed.
Thank you. Dr. Etter, I'd like to ask you, what is the first time when you talked with Mr. Apple about the stainless steel table?
I believe the first time I spoke with him was when I met with him in this building in his office on February 4th.
And do you know where the tables were at that time?
At the time I was speaking with him, I was not aware of where the tables were. Subsequent to that, I believe, based on a communication in the text from him to me, they had been moved by Mr. Apple and another individual on January 27th.
You know where they were moved to?
Again, without any independent investigation on my part, I was accepting his statement to me that they had been moved from his hunting land to the Juniata High School.
When you had the meeting with Mr. Apple on February 4th, did any other items of property come up in that discussion apart from the stainless steel tables?
He mentioned from lack that there were a pot or pan. There wasn't much of a discussion about that. The conversation,
I'm sorry, let me stop you. I'm sorry, I couldn't hear the first part of your answer.
a pot or a pan.
A pot or a pan, right?
The conversation was, as I testified the other day, was principally about the superintendent and his involvement. My understanding going into that meeting on February 4th was all that was taken from LAC on that day was 2 or 3 of her different versions, stainless steel tables. Also on the 4th, after Mr. Apple had indicated to me well into that meeting that the tables were taken to be used as meet tables, he then did mention that there were some chairs that he had gathered to use in the AEDY room, or whatever the place was that's attached to that acronym, which I understood to be something that's in this building or on the grounds associated with this building.
Do you know what the AEDY acronym stands for?
He said it to me, I don't remember what it is.
Right, so you've mentioned tables, pot or pan, chairs. Do you recall anything else being discussed?
No, nothing else was discussed. I recall that very clearly.
Did you have any follow-up communication with Mr. Apple on the next day?
When we left that meeting, I had indicated to Mr. Apple that I would report back to the board with what he had said to me, and then I would be back in touch with him. Early the next morning, I'm not sure the exact time, there are texts that will substantiate the time, I'm thinking around 9 or 9:30. I don't remember which order they came, but I first saw the text where he referenced a email would be coming to me, and with the text, he had a couple of images attached to that. I responded to the text saying I would look for the email.
Okay. Mr. Callen, at this time, we'd like to hand up some binders to the members of the board. That's fine. We have one for the witness also. Mr. Etter, I'm going to ask you please to turn to Exhibit 1. These are Mr. Apple's exhibits. This consists of 2 pages, and after you've had a chance to review it, I'm going to ask if you're able to identify this.
It's out of order. I believe that the wording of the text came first and the images came second. I think it may have all been a part of a text, but I mean, obviously there are a number of different entries there, so it appears that he sent me a number of texts. I'm assuming these are from February 5th.
All right, so actually, I think you were saying you thought the order was reversed. So would the pictures then be page 2 of this?
My recollection is that there was text and then the images were attached to one of the texts. Which one of those it was attached to, I don't recall. As it appears on this sheet, they're all jumbled together, so I don't know exactly what order it came in.
Okay, well, let's focus on the pictures first. Do you recall receiving a text with these pictures?
Yes,
And did Mr. Apple send this to you?
I received a text from what I understood to be his phone, yes.
Right, and this is on your phone you received this, right?
Yes.
And what did you understand these pictures to be Mr. Apple sent to you?
As I looked at it, I certainly saw the chairs, and I assumed that was what we had spoken about the prior day, that the chairs that he had collected for use at the AEDY room, the tables, I didn't really have any context for that from our prior day's conversation. The second image appears to be the tables, the third and fourth appear to be the chairs. The first image, I didn't know what that was when I got it, and I still don't know what it's intended to depict. And as I said, there was no conversation about tables or whatever is in that first image the day before, so I had no idea what they were. And I assumed, given that I had been given 3 days before that the inventory that Mr. Apple had taken on January 11th, I assumed that they were related somehow to the inventory that he was taking, but I did not know.
All right, so let me have you look at the actual texts now. And I'm going to ask if you recognize those.
He sent me texts those days. I mean, I don't have a clear recollection that those are the exact texts, but yes, he sent me texts that morning.
All right, and when you say that morning, are we talking about February 5th?
Yes,
So this was the day after you met with him.
correct.
And when you were meeting with him, you were primarily investigating Dr. Garber, correct?
Absolutely.
So the questions you were asking Mr. Apple were geared primarily towards Dr. Garber, right?
Yeah, as I testified the other day, I started out asking him about the Lego set, which to my knowledge then and now, Mr. Apple had nothing to do with. And ultimately, we did move into the tables from lab.
All right. The text here, the actual text, one of them says here, as I said, AEDY moved to my view, perhaps Mountain View Elementary yesterday. I brought in last evening the JHS. Any questions, please let me know. Sincerely, and then the next one says, a typed item email will be coming to show items moved to JHS and EJHS. Do you know what that means?
No, I don't.
Okay.
I mean, I received an email from him that I looked at and I read, but I read that and I assumed that that was part of his official duties on January 11th, and otherwise that he and others were involved in moving things around district property.
There is a line that says, thanks, I will keep a watch for the email. Was that your reply?
Yes,
And then it says, sent email with attachment. You recall Mr. Apple sending that to you?
as I said, I don't have a specific recollection of the series of texts that he sent to me on February 5th. I do recall in general that he sent me texts, and these are consistent with my memory.
Did you go back and review your text from that time period before testifying?
I went back and looked when I received a copy of the amended complaint, and a series of texts and emails were included as exhibits. I did go back and look at my texts and my emails from that time frame.
And did you have any reason to believe that anything attached to anything Mr. Apple filed in court was incorrect or forged or wrong?
The email itself and the attachment itself, with the exception of his handwriting, did appear to me to be the documents that I assume he sent. It came from an email with his name on it, and I received on the morning of February 5th.
Okay, so when you were cross-comparing, you did not see anything that struck you as being inauthentic, correct?
I was more concerned with looking at the email and the attachment to the email and seeing about the handwriting that was included on the exhibit to the pleading than I was looking at the specific wording of the text, because I did remember in general receiving the text and responding to it.
Okay, let me have you turn over, please, to exhibit number 2 here. And you made reference to an email and an attachment. Is this the email and is this the attachment you were just referring to?
This is the one with the exception of the pleadings, the sticker from the exhibit sticker from the pleading is not on it, but this is the version that was included, I believe, with the pleading. It's not the one that I received on the morning of the 5th.
Okay, now, I'm gonna ask you a couple of questions, but for purposes of my question, I'd like you to ignore the handwritten words on page 2 that say "on my ground." But do you recognize that as Mr. Apple's handwriting? Do you know his handwriting?
I do not know his handwriting.
Okay, so let me just ask you to ignore that particular language for now. Apart from that scribbling on the side, do you recognize this email as having been sent to you on February 5th?
I opened the attachment and read through it when it was, or when I saw the text. I went back and looked at the email and opened it and read through it, yes.
All right, and this email appears to be sent by Edward Apple, and the email address is eapple@jcsdk12.org. Do you know that to be the domain officially for the Juniata County School District?
Yes, I believe that is.
So, Mr. Apple, it appears from this email, would you agree, sent this on his official school district email?
I have no reason to doubt that.
Okay, did you investigate that?
Investigate whether he was the one that sent it or not?
No, investigate whether this was in fact sent on Juniata County School District email.
When I saw the pleading, I reached out to Mrs. Holderman, and because I'm not sure, I think what happened is the original email that I received went to my archive file, and for whatever reason, I couldn't find it. I asked Mrs. Holderman to resend it to me, and she did. So I'm assuming if she was able to do that, that means it was sent using the district's email system.
Okay, so let me ask you this question, because you said something interesting there. You said you went to your archive email folder, is that right?
My email system periodically will archive old emails, and for the life of me, I'm not sure how or why it does it, because it seems to do them out of chronological order.
Okay, so at some point, it was archived in your system. Do you recall seeing it in your inbox at some point?
Yes, I opened it, I read it.
Okay. Let me have you look at page 2, which is the attachment to this email. And just to save time, I'm going to read it here fairly quickly. It says, materials from elementaries, Roman numeral 1, placed in storage. Now, before I read the details of this, is this a description of furniture or items that you understood to be school district property?
I understood the various items listed to be school district property, yes, but I hadn't done any investigation. But yes, that was my understanding when I read through it.
Okay, so you had not done any independent investigation of this?
I was generally aware that different items were being moved to different locations, as I understood it, principally to Mountain View Elementary School, and a variety of people were involved in it.
Letter A says 3 kitchen tables dash stainless / 1 Hobart slicer / pots and pans from Lac, Tuscarora. Did you understand when it said 3 kitchen tables dash stainless? That was referring to the stainless steel tables you discussed with Mr. Apple?
No, I did not understand that at all. I was under the impression that there were a number of different stainless steel tables, and as I said a little bit earlier today, I was uncertain whether it was 2 or 3 tables, because I had been told by various people at various times it was 2, and then other people would say 3, and I understood that there were a number of different things. And when I read placed in storage as the predicate, I understood that to be that they had gone to Mountain View or some other district location, rather than if they had said taken to my camp, which is the handwritten clarification from Mr. Apple. If it had said that, yes, I would have connected those dots, but not in the way it was worded.
Okay. Did you follow up with him when you got that email?
I did not follow up with him when I got that email, other than I acknowledged that I would look at it.
So you didn't ask him any questions to explain this attachment?
I did not.
B says 12 chairs, 5 rollers, 7 cushions, 1 table from Thompsontown Elementary. Did you know what that referred to?
I did not. I mean, the district has hundreds of chairs going in different directions. I didn't, and I knew that there were a number of elementary schools that were being closed. I understood this, as I said earlier, that Mr. Apple on January 11th was involved in a district-wide inventory with various people. As part of that or associated with that, he and/or others in their official capacities were involved in moving furniture and other items from one building to another building. That's what I understood that to be when I read it.
And C says 2 metal kitchen racks / plastic pots hyphen from Fayette Elementary. Same answer, you didn't know what that meant?
I can certainly read and understand those things. I didn't know that his intention was to say that he had taken them from those locations and moved them to his hunting land.
And then it says, note, all items either in JHS FMR period, AEDY room, or JHS football and van shed concessions. Now, did you have any reason that you didn't understand that, or did you question whether that was truthful?
At that point in time, I was not questioning his truthfulness. I had met with him the day before. He had spent a lot of time telling me things that were not quite accurate. And at the end, he had told me that he was taking the tables to his hunting land for personal use as meat tables. And I thought, well, he is telling me something that's to his detriment that could get him into trouble. I assumed he was telling me the truth about that. I did not know what he was doing with these other things, and I did not conduct a further inquiry at that time.
You just said that he said several things that were not quite accurate.
Exactly.
Right. Turn back to the first page of Exhibit 2. The body of this email says, Dr. Etter, please see the attachment. Any questions, please let me know. Sincerely. And you're stating that you didn't ask any follow-up questions despite this invitation, correct?
He sent me a general statement in the email. He sent me a second page as an attachment that listed any number of items. As I said moments ago, the district was closing quite a few elementary schools. I understood at the time there was quite a bit of property in those buildings, chairs, tables, other supplies, and that they were moving them here, there, and everywhere. Mr. Apple was generally involved in some of that in his official capacity as Director of Secondary Education. I read that, and I knew also that Mountain View was being used as a central repository. I understood, or I read it to mean placed in storage at a district location, not at his hunting land.
But you would agree with me that Roman numeral 1, quote, placed in storage, unquote, doesn't say Mountain View. In fact, it just doesn't indicate where that storage was, right?
Mr. Martin, as I said the other night, I've been representing school districts for 26 years.
Okay,
Never.
No, that's not responsible.
Well, hold on, you're getting argumentative with him.
Well, he's not answering the question. I
Because
don't-
you're trying to argue with him. You've got his testimony about what he understood this to be. I think he's answered it clearly. I'd like you to move on to something else.
I can move on. Let's go to Roman numeral 2. Fayette and Thompsontown Elementaries. Would you agree with me that that does identify specific places on the district property?
Yes.
A, 2 pull-down screens, -1 for JHS football locker room, and 1 for possible ceiling mount in JHS library. Did you understand what that meant when you received the attachment?
I read it. My assumption was at that point in time that in his official capacity with the district, he was moving district property from one location in the district to another location in the district. I was not part of any moving plan or aware of the plan, and it made no difference to me that he moved something from one location to another.
D, 4-5 miscellaneous Windows laptops to JCSP Techs gave to Dan Mort at JHS. Did you know what that meant when you received it?
I read it. My interpretation or understanding of that was that in his official capacity with the district, he was moving district property from one district location to another.
I tell you what I'm gonna do. I'm gonna read down through the rest of this page. If you wanna give the same answer for everything you may. C, 1 ball pump to JHS athletics was in trash can. D, one small drawer to EJHS office. Roman numeral 3, other items. A, student backpack. B, kitchen rags in bag dash in trash dash can be used for concessions. C, floor scuffs dash for chair bottoms. D, power strips dash 2-3 in trash dash. E, rulers and meter sticks dash on floors dash shipped with JES and EJES supply boxes. F, teacher desk file organizers / bookends. G, staplers / hole punches / tape dispensers dash shipped with JES and EJES supply boxes. H, 33 balls picked up at Tusk Valley for JES, placed in trash cans for JES. Roman numeral 4, moving crew move following types of items, : A, tables, round tables, chairs. B, shelves, 2-door cabinets.
Attorney Martin, please slow down.
I'll go back to B. B, shelves, 2-door cabinets. C, teacher desks. D, TVs / carts. E, coat racks. F, modular : tables and library shelving. Is it your testimony that you believe that this attachment was the inventory that had been done on January 11th?
No, the inventory was very lengthy. It was, the district, again, as I said moments ago, was closing quite a few elementary schools that were stocked over the course of ensuing 50 or more years for some of them. There were quite a few tables, there were quite a few chairs, there were quite a few pots and pans. This would be a fraction of what was addressed on that inventory, and I interpreted this to be that Mr. Apple, for Roman numerals 2 and 3 and the items listed under that he was personally involved or he himself moved those items. With respect to the items under Roman numeral 4, unless he was part of the moving crew, whatever that was, moved those items, although he may have been a part of that.
Is there anything on this page that you can identify as being a false statement?
I know, as I told you earlier, I didn't do any independent investigation. If he was making a representation that he moved one item from a district location to another district location, I was not asked to look into that. That was not my concern.
Okay, so as far as you understand, when the administration is saying that Mr. Apple made intentional false statements, that does not apply to this document, Exhibit 2, correct?
I clearly said when I testified last week that the intentional false statements were in the pleadings that were filed, both with respect to the complaint and the affidavit, and the complaint being supported by a verification. I did not testify or say anything about this document.
Right, the administration is trying to terminate him in part based on the lawsuit he filed, correct?
Not at all.
What did you just say?
Statements that he made in the lawsuit that were materially false, or at least materially adverse to the statements that he made in an investigatory interview with the interim superintendent.
Did the school district at any time raise with the presiding judge in that case an allegation that Mr. Apple had made intentionally false statements in that lawsuit? Was that ever raised with the presiding judge?
Mr. Martin, I believe the case itself was decided in a preliminary fashion when a motion for judgment on the pleadings was granted. I don't believe the case ever was decided on its merits, so that issue was not decided by a judge, but I believe that the answer that was filed on the district's behalf absolutely said that what Mr. Apple said was false.
And the district never moved for sanctions, never sought to hold Mr. Apple in contempt, and never directly to the judge said that it believed that Mr. Apple was making intentionally false statements. Isn't that a fact?
Mr. Martin, as I said moments ago, the case was decided on a motion for judgment on the pleadings and never got that far. I'm certain that that issue would have been brought up with the judge had the motion for judgment on the pleadings not been granted in the district's favor.
Okay, so you're talking about hypothetically what the district might have done in that lawsuit if it hadn't been resolved by way of a consent decree that the district itself agreed to. It's Isn't that what you're saying?
I'm not saying that at all.
Can you give a yes or no answer to my question as to whether the district ever brought up with the presiding judge the allegation Mr. Apple made intentionally false statements in that lawsuit?
Well, you're just arguing back and forth. You've already said it in the school district's answer.
I was asking if it was ever brought up directly with the judge, because that would.
I mean, other than the answer that they gave to the judge?
Correct, in any colloquy in front of the judge.
Dr. Etter, other than the school district's answer, in the course of the proceedings that were terminated before it went through the full trial, the school district raised the issue that Mr. Martin has asked.
I was not present for one of the sessions, so I don't know what Mr. Repack may have said or did not say.
Let's move on from that.
When was the first time you became aware of an issue involving Slicer?
The meat slicer.
Correct.
Let me step back. You had asked me what all Mr. Apple said to me on the 4th. The meat slicer was mentioned then as well.
Oh, anything else?
No, Mr. Martin, that was it.
Okay, so now you're remembering the meat slicer also.
You just refreshed my recollection when you
very
mentioned
good.
that.
Let's not have sarcasm. You have questions you're asking, ask the questions. He'll answer. You refreshed his recollection. He acknowledged it. I don't think we need to have acrimony to answer
Well,
your question.
sir, I bring up the point that the allegation was made is that Mr. Apple made intentionally false and misleading statements. And this is critical as to whether Mr. Apple, in meeting with Dr. Etter, who has been presented by the administration as the investigator, disclosed certain items and at what time he did. This is absolutely relevant to this
I'm not
question.
stopping you from asking the question. I said just don't have sarcasm with it. It's not necessary.
The
It's the
pleading, excuse me, the pleadings themselves and what the district has said are the material false statements do not include the meat slicer itself.
Okay. When you were questioned 15 minutes ago or so, you did not mention that the meat slicer was discussed during the February 4th meeting, correct?
Correct.
But it was in fact discussed.
I told you that, yes.
All right. Is there anything else that you could look at that would help to refresh your recollection as to what was discussed during that meeting?
I don't know.
And when you gave that answer, omitting reference to the meat slicer, you didn't do that intentionally, did you?
I did not.
Okay. That was just a mistake, right?
It was a mistake.
All right. Let's move forward here. When was the next time that you communicated with Mr. Apple
In
about
person.
about the subject of this school district property?
In person or otherwise.
In any fashion?
I don't believe, although this is many months ago and I have not gone back to check one way or another, I don't believe he and I had any communications between the time that I left his office on February 4th and the email and text exchange the morning of the 5th. I don't believe we had any further communications until I sent him a text on the morning of the 11th. I may be mistaken in that, but that's my recollection.
I'd like you to look, please, at exhibit number, well, wait a minute. Before we do that, why are you saying you might be mistaken?
I don't have a picture-perfect recall of every event in my life from, 6 months ago.
Well, did you keep notes in the course of your investigation?
I did.
Did you review those before testifying?
I reviewed them, not today, but I've reviewed them in the past, yes. But my notes don't necessarily reflect everything that I've done. So there may have been, Mr. Apple and I communicated frequently over the 20 years that he and I have known one another. So we could have been communicating on other matters involving the school district unrelated to this. I don't remember.
So are you saying that even the notes you made in the course of this investigation don't necessarily reflect what happened in the investigation?
No. If I interviewed someone or I did something in furtherance of the investigation, I would write it down. If I had a phone call from Dr. Yarger or from Mr. Apple that related to the school district but did not relate to the investigation, depending upon what it was, I may have written it down or I might not have written it down.
So your testimony today is you're not sure if you communicated following the email text exchange of February 5th and then when you met with him on February 11th, or communicated by text then?
I said 6 months after the fact, 6.5 months after the fact. I have no specific recollection of any communications with Mr. Apple between those two events. There may have been some, but I don't recall them.
All right, now I'm going to have you look at Exhibit 3. Can you identify what Exhibit 3 is?
This is what I was referring to as the communication late in the morning on February 11th. Although, if I'm saying, are you available on 10:15 or 10:30, I'm assuming that 11:52 a.m. above that's not accurate. Or accurate, but it's referring to something else.
If you look at it, you'll see that block starting about half the page to the right at 6:29 a.m. And the next one has 6:38 a.m. Would you please read that block?
Well, first of all, if the text is the text, and you can show Mr. Apple's phone that it was sent at that time, I'm doubting that I sent it at 6:29, but I may have. You would like me to read the text?
I would, please.
Allowed or?
Yes, allowed.
Quote, "Are you available at 10:15 or 10:30 this morning? Your job is secure, but I need to discuss with you the sanctions that the board wants to put in place as a condition. Let me know, thanks."
And did you send that text to Mr. Apple on February 11, 2019?
I did.
Why did you say to him, I need to discuss with you the sanctions that the board wants to put in place? Have you met with the board?
As I testified last week, I met with the board on February 7th in executive session. I spent the majority of my time in that executive session updating them on where I was with the investigation about Dr. Yarger, and I did say that I had met with Mr. Apple and what Mr. Apple had said to me about the meat tables, and I made a recommendation at that time for a potential sanction for him.
And so when you were sending this text on February 11th, it was at the request of the board, correct?
It was not at the request of the board. I was merely following up with something that the board had authorized me to do, and I was checking because I knew that Mr. Apple had 2 offices in the district, and sometimes he was here, there, or everywhere else, not necessarily in those offices, and I wanted to make sure that I could meet with him at some point.
But you were doing what you understood the board wanted you to do, correct?
I was doing what the board had authorized me to do based upon what Mr. Apple had admitted to me the week prior.
And am I correct that you then sent a text that said high school question mark, and then Mr. Apple responded, yes I am dash at Juniata today,
Says what it says.
correct? Do you recall having any other communication with Mr. Apple on February 11th before you met with him in person?
As I sit here today, I don't have a recollection now.
Did you in fact meet with him on February 11th?
I did.
And where did you meet?
In his office at Juniata High School.
And can you describe what his office looks like?
Well, to me, the most outstanding feature would be he has about 3 or 4 trophy bucks in there. He also has some baseball memorabilia. I mean, it's a small office. I met him in there, I don't know, 10, 20 times over the years. The Bucks dominate the office, and that's the most outstanding feature in every respect of that word.
And there's a desk there, obviously. And how many chairs do you recall that thing?
He has a desk that would be facing the door. As you walk in, I'm guessing it's a rectangle, but it's pretty close to a square. I would estimate it's 8 by 10. It's pretty small. He's got a desk that sits on the left wall facing the door that comes in. And I believe that there are 2 or 3 chairs on the wall facing his desk, and there might be a chair on the wall to the right, but I'm not 100% certain of that.
Do you recall where you sat that day?
I sat on one of the chairs facing his desk, on the wall where the door is located.
And did you sit where it was right as you walked in, or did you move it?
I don't believe I moved it.
You don't have a specific memory, correct?
don't have a specific memory of that. I have a specific memory of my interactions with Mr. Apple. Where the chair was situated, whether I moved it or not, I don't think were material to me. The chairs are bunched together, and I don't think even if I had tried to move the chair, I could have moved the chair. There wasn't enough room.
When you sent this text before the meeting in his office, what did you mean when you wrote your job is secure?
Mr. Apple on the 4th was very emotional. I felt for the guy. He was concerned about seeing his daughter graduate from high school. He was concerned about losing his job. I was trying to calm him because I felt for him.
And in fact, am I correct that in your representation of the school district in the past, you've never dealt with an allegation that Mr. Apple has stolen property or been untruthful, correct?
No, not that I can recall.
And you're not aware of him having a reputation of being untruthful, correct?
The only issue, as part of the investigation I was engaged in with Dr. Yarger, I was told by personnel in the administrative office that they were concerned about tracking Dr. Yarger and Mr. Apple's movements around the district. And there was a concern about where they were and whether they were working. That, I think, gets a little bit to what you're talking about. That one instance is all that I'm aware of.
Okay, and that was all part of this time period when you were doing this investigation, correct?
I've not been told this going back 10 years, no.
You've not been told this what?
I have not been told in the past of that issue. This is something that someone would have told me if I did not start meeting with people until February 1st of this year. That would have been the first that I heard of that particular issue involving Dr. Yarger and Mr. Apple.
Okay.
Which I think falls under the general heading of the question you asked me.
When you met with Mr. Apple on February 11th, how did the conversation go?
I told him that I had met with the board and that I had prepared a document, the 3-page document that are in the district's exhibit book, I believe is exhibits 30 and 34. And it was in 2 parts. One was the disciplinary sanction that I went through with him. The other was the statement about what he had done on January 1st with respect to the meat tables that he took to his hunting land.
I'm going to ask you please to look at page 3 of Exhibit 4.
Yes.
This page 3, does this memorialize the entirety of your conversation with Mr. Apple?
On the 11th or on the 4th?
Wait, hold on. Conversation from what day, that day?
On February 4th in particular, because you brought this to the meeting on February 11th.
No, as I said, when I testified last week, Mr. Apple and I met for about 45 minutes on the 4th. We talked about a considerable amount more than what's on this document on 1 page and 6 numbered paragraphs.
And I'd like to ask you what Mr. Apple said when you presented this to him. You said the board has asked me to get this brief to sign.
He didn't say anything. He was emotional, as he was before. He was still very concerned about seeing his daughter or one of his daughters graduate. I'm not sure what grade she was in at the time.
So he did say that.
He said it both times. He was extremely concerned about that, yes.
I'm specifically asking what he said to you February 11th after you presented this document.
He didn't say anything about the document. He expressed to me further concern. The document reflected what he had said to me on February 4th. There wasn't anything to discuss about it. I asked him to read all 3 pages, to sign them. He did. I signed as a witness. I asked him to make a photocopy so that he would have a record of what I had. He briefly left his office. I assume made the photocopy on the photocopier in the main office, came back. We had a relatively brief conversation after that, and I left.
I'd like you to look at paragraph 6 on page 3. It says the superintendent and I unloaded the tables, comma, and the intent was that they were to be left there as, quote, meat tables, unquote. Would you agree with me that the second clause in that sentence, and the intent was that they were to be left there as meat tables, does not identify whose intent that might have been?
I think it certainly suggests that it's the superintendent and Mr. Apple who are doing this collectively. My understanding, based upon what Mr. Apple had told me on the 4th, and then he repeated several times after that over the months, was that Dr. Yarger had contacted him at some point in the early afternoon on January 1st. They had met at what was then called Fermanagh Mifflintown Elementary School. They had driven to Lac Tuscarora Elementary School. They, along with the 2 janitors, had loaded, again, I've heard different stories, 2 or 3 stainless steel tables, and then they drove to Mr. Apple's hunting land. They unloaded them, and they were to be used there as meat tables. My understanding was that they hunted on this land. Dr. Yarger did. He had a small bear trophy in his office that I was told had been shot on Mr. Apple's land. I interpreted what he had told me, that they both intended to use it as meat tables. It was Mr. Apple's land where they were going. And he was a hunter, as I understood it, based certainly on the trophies that he had displayed in his office.
So that was your understanding, but my question actually was, wouldn't you agree that the second clause in paragraph 6 does not identify whose intent that was to use those tables as meat tables?
It says what it says.
Right, and you wrote this up following a meeting with Mr. Apple, in which the focus of the investigation was on Dr. Carter, correct?
The focus of the investigation as it started was clearly on Dr. Yarger. As the issue developed about the stainless steel tables from LAC, the focus on that aspect of what I was engaged in was equally on Dr. Yarger as it was on Mr. Apple.
And you explained that in so many words to Mr. Apple when you gave him this document. Is that your testimony?
I did not explain. Mr. Apple is an educated man. He's been involved in public education for a period of time. When I met with him on the 4th and I was asking him questions about a superintendent that was accused of stealing things from the district, including something that he had allegedly done with Mr. Apple, I didn't think I needed to explain to Mr. Apple that he too was in potential jeopardy for having been involved in taking property from district location to his personal hunting land.
So you didn't advise him of that?
On that particular day, I did not.
And isn't it also correct that at times you provided advice to Mr. Apple as to how to respond to the situation?
I absolutely did not. On 2 occasions, as I testified last week, Mr. Apple asked me about whether or not he should engage counsel. The one was when he called me on my best estimate is March 12th, when I was on my way to a school board meeting at Bellefonte, and he indicated that he was being asked to submit to a criminal investigation interview with the state police. He asked me whether he should retain counsel. I told him, I'm not your attorney. I represent the school district, which has an interest that is adverse to yours, but I thought you would be foolish not to engage counsel if you're talking to the state police and you were a potential subject. The second time I made a similar suggestion to him was on April 18th, when Dr. Kovac, the interim superintendent, and I met with Mr. Apple and his criminal defense attorney, Mr. Shore. And Mr. Shore, in the course of that meeting, repeatedly said that he was not equipped to advise Mr. Apple on employment matters. I urged Mr. Apple at that point in time to contact the Principals Association and engage counsel who could properly advise him.
I'd like you to turn over, please, to exhibit number 5. Can you identify exhibit 5?
Again, it's a series of texts between Mr. Apple and me.
would you agree that they were exchanged on February 18th?
The first two are from February 18th,
And then there are a couple more from February 21st, right?
correct?
And am I correct that you initiated the texting on February 18th by saying, "How are you doing?"
As I said last week, I consider Mr. Apple something of a professional friend. I was concerned about him. Yes, I did initiate it, asked about his well-being.
And Mr. Apple responded, "Just unreal, I am alive, may I call you or no?" That's a response, correct?
Yes, that's what it appears to be, yes.
And then the text messages ended on that date, and it looks like February 21st started again, and Mr. Apple wrote to you, "In your opinion, should I go to board meeting tonight, question mark. I know some people, et cetera, will be there. May blast me according to Facebook, comments, et cetera, just asking." And in response, you said, "I would say yes, better to face people in person." Now, you wrote something else, but I'm going to stop there for now. Is that accurate?
It's what the text says.
So you advised him that you thought it was better for him to go to the public meeting, correct?
If you're suggesting that that's legal advice, I don't believe that's legal advice. I was responding again to someone that I considered something of a professional friend, and I believe rather than hiding from criticism, it's better to be present and face the criticism.
I wasn't asking about legal advice, I'm just asking about advice. You agree that's advice, right?
It's a suggestion in response to a question he originated with me.
Okay, and then in your text, you go on to say, "But Danny and Amy are the people with real say, not me." Now, what did you mean when you wrote that?
As I said last week, and as other people have said, and as you and I have discussed prior to this day, there was a vacuum in the administrative leadership of the district. Certainly that day, I believe we were at or about the time when the board was accepting the resignation of the superintendent. There was no administrator above Mr. Apple to go to and say, should Mr. Apple attend the meeting? I'm the solicitor. I don't make calls like that. In the absence of a superintendent, I certainly would rely on the board president and vice president to make a determination of whether a certain administrator should go to a board meeting or not. And in fact, in response to that text, I sent a text to Mr. Snyder and Mrs. Wagner and said, does Mr. Apple need to attend the meeting? This is a paraphrase, I don't know, it's a quote. I asked them, they said he did not need to attend.
Now, as of this point, on February 21st, I believe in response to my earlier questions, you said that Mr. Apple should have realized that he was I don't know that you use the word target, but I'll use that for lack of a better term, of an investigation that's going on, correct?
On February 1st, as I said last week, I believe when I met with Mrs. Holderman in the morning, that was the first, I think, that I had Mr. Apple's name connected with the LAC tables, but I may have heard when I met with Dr. Yarger on the 29th. Either way, it was not very well developed at that point in time. On the 4th, I was still formulating whether or not I thought they had taken tables to store them, as Dr. Yarger was claiming, or if they were taking them for personal use. And I was asking Mr. Apple on the 4th about various matters. Again, the primary focus at that point in time was Dr. Yarger and what he might have done. And it certainly, on the 4th, I asked Mr. Apple about many different things involving Dr. Yarger, none of which he was involved with.
And Dr. Etter, following up though, I'm asking now about February 21st. You testified that on February 11th, when you handed the document to Mr. Apple, that he should have realized that he was personally being implicated somehow. Isn't that what you testified to?
Mr. Apple had specifically told me on February 4th that they had taken the tables from LAC to his hunting land for personal use as meat tables. I think he implicated himself on that day.
And you also testified that your only advice to him legally was that he should get a lawyer.
Again, that was not legal advice. I told him, I'm not your attorney. He asked me a question, I told him, I don't represent you, I have a client with an adverse interest to your position, but I thought you would be foolish. I gave that advice to him as a friend, not as an attorney. I clearly was not his attorney.
Mr. Martin, we seem to be going in circles here.
Yes, I'm gonna wrap it up with the document. I'm gonna approach the witness to refresh his recollection, perhaps. Dr. Etter, did you ever speak with Mr. Apple or communicate with him to recommend what he do with respect to an investigation by the Pennsylvania State Police?
If I did and you have it, I'd like to see it. I don't have a specific recollection, other than what I told you on March 12th during a phone conversation. Wait a second. Are you referring to when Trooper Varner asked me to put him into contact with various district witnesses for an investigation he was doing? Is that what you're talking about?
You know, I think I just had to ask a pretty broad question.
Okay, I will answer your question. Well after Mr. Apple had executed documents, which he executed on February 11th, at the request of the district attorney, I, two board officers and Mr. Miley, met with the district attorney and Trooper Varner. That was on February 27th at the courthouse. On 2 occasions following that meeting, Trooper Varner sent me an email with a list of district witnesses, whether they be employees or board members, who he wanted to question about various matters involving Dr. Yarger and potentially Mr. Apple. He asked me to provide contact information for them to include emails and cell phone numbers or office phone numbers, and he asked me on behalf of the district to ask them to cooperate. That came from the fact that prior to February 22nd, and prior to the resolution of the matter involving the superintendent, the then superintendent, I had told all board members who had been contacted by Trooper Varner to tell him, until we wrap up the employment matter with the school district, we will not talk to you. At that point in time, I sent emails probably to 10 or 15 district employees as well as board members saying, Trooper Varner may be contacting you, please cooperate. I sent that as the solicitor of the district on behalf of Trooper Varner making a request to further his investigation. If that's what you're referring to, I did send an email to Mr. Apple, as I did to everyone else. It wasn't legal advice.
Do you recall sending an email in which you said to Mr. Apple, please cooperate with him, referring to Trooper Varner, and answer his questions to the best of your ability?
If you're going to show me the email, I'll authenticate it or not.
Well, I'm asking if you remember that.
I just told you what I remember. I don't have a specific memory of what I wrote in the email, other than the email was substantially the same to everybody with a little bit of change here and there depending upon the person's position.
He's an idiot.
Do you recognize what I just handed you?
Other than the handwriting on it, yes. And as I see at the bottom, which I'm assuming again is Mr. Apple's handwriting, advised to seek counsel, and the name is Nevin Zimmerman, which is the name I gave him. I don't know who Sean Curry is. I assume he came up with that on his own.
Let me ask about what you printed on that email. Would you read that email?
The handwriting or the text of the email?
The text of the email.
February 27, 2019. Dear Ed, as you are aware, the Pennsylvania State Police are investigating allegations of criminal wrongdoing, and Trooper Varner would like to speak with you. I believe he would like to address what occurred on and after 1/1 at LAC, but may have other questions. Please cooperate with him and answer his questions to the best of your ability. If you have questions, please call me at 814-777-2625, which is substantially the same email that I sent to the estimated 12 to 15 other people that Trooper Varner wanted to speak with.
So is it your testimony that when you wrote a letter that began "Dear Ed," Mr. Apple, and said, please cooperate with him and answer his questions to the best of your ability, you were not rendering legal advice?
I was not.
Now, well, was this a directive? I mean, what was this directive?
It was doing something that was asked of me by Trooper Varner, and at that point in time, I believed that we had wrapped up everything that involved Mr. Apple.
I'm going to have you turn back now, please, to exhibit number 4. On page 1, there's a sub-paragraph C. And it says, notwithstanding his, and I think we can all agree that it's referring to Mr. Apple, status as a tenured professional employee. Employees shall be placed on a probationary status for a period of 1 year from the date of this agreement, and any substantive violation of any applicable statute, rule, regulation, or policy shall be sufficient grounds for his dismissal. I'd like to ask you specifically about that phrase, substantive violation. Is that defined anywhere in this document?
It was not.
And am I also correct that this document is silent as to whether a substantive violation that could trigger this paragraph would be something that had occurred before or after the date of this agreement?
It does not specifically address that.
Am I correct that when the 5-day unpaid suspension was recommended by you, and when this document was given to Mr. Apple, you didn't believe that he had committed criminal felonies, did you?
I'm not a criminal defense attorney. In 26 years of practicing law, I did one preliminary hearing, so that's my only knowledge of criminal matters. I did reach out to one of my former partners who had been a 2-term DA in Center County and asked her briefly about the issues and what her feeling was. And she had indicated to me it would depend upon the value of the property that was taken. I did not do any further investigation other than to spend maybe 2 minutes doing a search on eBay to see if I could find stainless steel tables. I didn't know the size of the tables, but I was estimating that each table might have been worth a couple $100. And if there were 3 of them, they were each worth a couple $100. It potentially was at the level of a felony. I only did that out of curiosity, not for any official purpose, and I didn't do anything further with it.
But am I correct that you didn't believe that Mr. Apple had committed a crime?
Oh, I did believe he had committed a crime. He had taken school district property.
Well, if you believe he had committed a crime, why was the only recommendation for a 5-day unpaid suspension?
Because I had looked at the matter from a holistic standpoint, that I was not aware of significant evidence of wrongdoing during the course of his career. I, of course, was aware of the public reprimand that he had received, I believe, in 2014, and I was looking at this in the overall scheme of things. I absolutely bought his narrative, and I believe it's accurate to some extent to this day, that he fell under the influence of an individual who was not particularly smart about what he was doing. And I considered all of those factors as I was fashioning a sanction to recommend to the board. I don't know about you, but Mr. Apple has had a relatively high salary, a 5-day suspension without pay, a provision that he would not get a raise that year. That in particular would have a very significant impact on him going forward to lose out. I'm not sure what the Act 93 agreement provides for, but a 2.5% or 3% raise compounding over the rest of his career is a relatively significant issue. The fact that he would agree to move from his position if the board chose to reorganize the administrative structure, that he would agree to move from the director of secondary education back to a principal position, I don't know about you, but from a school law standpoint, those are very significant sanctions that he got.
And with respect to this 5-day unpaid suspension, are you suggesting that there was certain information about property that he had moved that you didn't know when this agreement was presented to him?
I certainly, as you have pointed out, have received an email with an attachment that he's now able to point out and say that's what I was referring to on April 18th when I told you and the interim superintendent that I had taken things from 2 other elementary schools on January 12th. Those dots have not been connected, and the very cryptic and general language that he provided to me gave me no way of specifically knowing that. So did I have it in my possession as of February 5th? Yes. Did he make it clear to me? No. Do I, as I've been sitting here today, think he intentionally did that? Yes.
Okay, so that's your opinion, but even though his covered email invited you to contact him with questions about it, you did not, correct?
I already said that.
Now, given this substantive violation term is not defined in this document, what is it specifically that the administration is saying that Mr. Apple did that violated this?
Again, I don't know about you, but I think a second instance where he went onto school, 2 buildings and stole school property is substantive. I also believe that the events that occurred on his birthday, where he, as the principal and the person who is in charge of the building, participated in his own birthday lunch that was paid for with district funds, where he consumed 3 alcoholic beverages when he was still on the clock. Then he proceeded, after driving by 2 elementary schools, to go to a friend's house, where still on the clock he consumed another alcoholic beverage. Again, I don't know about you, but I consider both of those instances in isolation to be easily meeting the standard of substantive.
Which, now, when you're saying stole school property, so you're saying that certain items beyond the stainless steel tables that you say you were not aware of, that you did not understand Mr. Apple having sent the email to you about, that's the basis for getting out of this agreement?
I'm not getting out of the agreement whatsoever. The agreement has full force and effect. The agreement references additional substantive violations, which is what we're talking about. That agreement is solid. He did something that further applies from the language of the agreement. And if you're looking at the 3rd version of the statement of charges, specifically paragraph 8, what he took on January 12th.
Okay, so just so I'm clear, you're saying when this agreement was presented to Mr. Apple, you didn't understand yourself that there were other items that he had removed from school property, is that right?
Mr. Apple had made it far from clear that on January 12th, he entered 2 additional elementary schools and took other district property and moved them to his personal hunting land.
Well, why didn't you investigate? I mean, are you a trained investigator?
I'm an attorney who's been practicing law for 26 years. I've been involved in many investigations in the school district. Have I taken specific courses like an FBI training course? No.
Well, don't you think though, if you get an email from someone you've interviewed,
I
you should...
don't want to have more argument on this. I mean, you've asked him, did he know that he connected the dots as the January 12th? And he said no.
You mentioned drinking alcohol on what you said was school time. Would you agree that if he was not on school time and had taken the afternoon off, that that would not be a substantive violation of the terms of the agreement?
So that he is, we're not talking about the use of school district money to pay for his lunch?
No, I'm asking specifically about alcohol, because you raised that issue. That he had consumed alcohol. Would you agree that if he did it on time off, that would not be a substantive violation of this agreement?
But to be fair, you want clarification. Your question is, leave aside whether or not, but leave aside the birthday lunch. Your question is, if Mr. Apple consumed alcohol that wasn't on school time, would that be a violation of your Exhibit 4?
So this coming Saturday, if if he goes to the red zone, has lunch, pays for it himself, has 2 beers and a shot, as long as he's not falling down drunk or belligerent or something of that nature, no, I don't think that would be a violation. But he's paying for it himself, and he's not on school time. I don't believe that would be an issue, provided that he's not falling down drunk or loud and belligerent.
And am I correct, your answer would be the same as of June 18th of 2018, if he were not on school time, correct?
I believe it's June 19th of 2018.
Okay.
My answer,
Either day?
excuse me?
Either day?
Well, the issue with June 19th of 2018, which I believe is the correct date, is all of those things were tied together. So you're asking me to address an issue that did not occur.
All right, well, let's assume the date was June 19th, 2018, and I do see the safety charges listed as the date. If in fact Mr. Apple had taken the afternoon off and had been at the red zone and consumed alcohol, you would not view that as a substantive violation of this agreement that was entered into, correct?
And we're assuming that he as principal was not present when $100 of school district money was used to pay for the lunch and the alcohol.
Well, that wasn't my question, that could be a different one. I'm just asking about alcohol.
In isolation, I already answered that question. In isolation, if he had...
Hold on, he did already answer.
Attorney Kaplan, you still have a microphone near you. You don't have to hold it.
He did already answer it. Let's move on, please.
This is getting on my nerves. I could just find a gun on you. Also,
Before you presented the document to Mr. Apple on February 11th, had you emailed it or otherwise given it to him to review?
I had not.
Is there any reason why you didn't?
I believe it was a relatively early morning. I was leaving my house at whatever time I left my house, depending upon what was going on with the construction in Potter's Mills. It could take me anywhere from 35 minutes to an hour and a half to get there, and at that point, I actually may have been driving through, can't think what over toward Kish Valley, and at that point, it was taking me more than an hour and a half. So, no, I did not. I was somewhat pressed for time. It was, in my view, then, and still is, relatively straightforward. The third page is my best attempt at a verbatim understanding of what he had said to me on February 4th. The issues that are on pages 1 and 2 are for an educator, and certainly someone who had been an administrator like Mr. Apple has for many years, are pretty easy to understand. And it's not, I have a document that I use as a settlement agreement with school administrators that's about 25 pages long. This obviously was much shorter.
Why was it much shorter?
It was much shorter because it was simple and straightforward with what we were doing. This was my version in the absence of a superintendent or interim superintendent. This is what that person would likely have done in a 1 or 2 page letter, starting off with his address and saying, "Dear Mr. Apple." This is simply the short and sweet legal version of that letter.
Would you agree that in the court cases that referenced, you signed and yourself verified a plea in which you used the word vacuum to describe leadership of the district during this era?
What's your question?
I'm asking, did you use that word?
I have used that word many times. If it's in the pleading, it's in the pleading.
Okay. Do you agree with that characterization, that during the early part of 2019, there was a vacuum leadership in the school district?
What's the early part of 2019?
The end of January, the beginning of February of 2019.
As of January 28th, and maybe even a couple days prior to that, but certainly as of January 28th, the then superintendent was in a compromised position. As of February 11th, when I asked him to leave his office and leave his keys, there was absolutely a vacuum. Between the 28th and the 11th, there was a little bit of a flux period.
When would you say the vacuum lasted until?
till February 22nd, when Dr. Kovacs was named the interim superintendent, and he hit the ground running.
Thank you. I don't have any other questions.
Redirect.
If you can turn to the second page of capital exhibits. Handwriting is beside Roman numeral 1. It says on my ground. That wasn't one version of that page when you received it, correct?
No, and I have the true copy in my file if you would like it.
And you did not interpret place in storage as meaning on Mr. Apple's hunting.
No, as I said, I was aware that Mountain View was to be a central repository. I thought there might be some other locations, but no, I certainly did not interpret that to mean his hunting land.
And then with regard to page 3 of the Apple Exhibit 4, the paragraph 6. When you included in the intent was that they would be left there as meat tables, did you mean it was Dr. Gardner's intent, or whose intent did you mean to imply with that when you compared the document?
Prior to the comma in that numbered paragraph 6, it says the superintendent and I wrote it with the understanding that it was Mr. Apple's land, Dr. Yarger and Mr. Apple, and I presume other people too, but at a minimum, those two hunted on that land, and I presumed that it was their collective intent that it was to be used as meat tables. They were to be used as meat tables.
And after Mr. Apple, well, let me ask you this, did Mr. Apple, when you presented him with this document, tell you that he did not want to sign it because he believed that that was incorrect?
He did not.
Did Mr. Apple, during any of the subsequent conversations that you had with him after he signed this document, indicate to you that what was set forth on page 3 of that exhibit was incorrect?
The only subsequent conversations I had with Mr. Apple, whether they be text, email, or in person, or on the phone, where that issue was discussed, was during the meeting on April 18th with Dr. Kovacs and Mr. Apple's attorney, Casey Shore, present, where he used the phrase something to the effect, as I previously told you, they were there for meat tables. And then on May 10th at the Loudermill hearing, when I orally went through the proposed statement of charges, and that was one of the charges, there was no objection by either Mr. Shore or Mr. Apple.
No other questions?
I do have a follow-up. Dr. Etter, you made reference to a Loudermill hearing. Am I correct that that is a preliminary proceeding for an employee of a school district who may be the subject of possible employment discipline?
Can be.
And am I also correct that an employee has no duty to speak in response to any charge that's read at a Loudermill hearing?
They do, but at this particular Loudermill hearing, and as I testified last week, Mr. Apple strongly contested one of the charges. I did subsequent investigation, determined that he was correct on that issue, and I removed it.
But I am correct that it is not a requirement that an individual school employee respond to every charge that's stated at that Loudermill hearing, is it?
Mr. Martin, on February 4th, he told me he was taking them for personal use as meat tables. On February 11th, he
Okay.
signed a document to that
This is
extent.
not responsive.
On April 18th,
Well, hold on. Why don't you ask the question again?
Dr. Etter,
Answer the question, thanks, please.
is it true that at a Loudermill hearing, a school district employee has no duty to answer all or any particular part of the the charges that were presented at that time of the hearing, correct?
He was the source of the information for me on that subject.
Okay, is that a yes or a no?
He was the source of the information for me on that subject.
Dr. Etter?
Dr. Etter, could you try to do a better job of answering these specific questions?
I don't believe he has an obligation to address every issue.
Thank you, no other questions.
Just to follow up to that, did he address issues though at the May 10th follow-up hearing?
He addressed the issue that there was a concern that he had unilaterally imposed parking permit fees and perhaps some other fees. He very strongly reacted to that, said he didn't do it, that it was done by the board. That was the only issue that he contested. His attorney, Mr. Shore, didn't contest any issue, but he asked that when I had written initially that he was under the influence of alcohol on his birthday, that I changed that to consumed alcohol. I thought that was a reasonable request and I made that change.
No other questions?
I have a point of clarification I'd like to address with you. This goes back to your...
Attorney Calvin.
I have a point of clarification I'd like to address with you. This goes back to your direct testimony. You have testified that in your investigation, you were told that Mr. Apple and two other employees, after the birthday lunch on June 19th, 2018, had driven to and viewed the progress of construction at Juniata Elementary School and East Juniata Elementary School. Is that correct?
Yes, although I think one of the changes we made in the statement of charges is we reversed the order that they went, I think, first to EJ and then to Juniata Elementary. But yes, they had done both of those things after lunch.
And the point of clarification I wanted to understand was, do you know whether viewing the progress of construction at those two schools on that afternoon was part of Mr. Apple's job duties? Was he doing that as part of his job performance or some other reason, if you know?
They were elementary schools. He was director of secondary education. I didn't think it was specifically his role, but I didn't consider it not his role to be involved in something like that.
I have no further questions on that. Did that clarification prompt any questions? Does the board have any clarification questions? Okay, Dr. Etter, you may step down. Thank you. We'll take a 5-minute break.